Clerk, can we turn the TV off or mute it?
Okay. Good morning and welcome to the Maryland Public Service Commission's rulemaking session in docket number RM75. We are on the record. By issue noticed on November 16th, 2021, this has been designated as the time and place for the commission to review proposed regulations that were filed by commission staff on November 15th, 2021. Comments were then requested to be filed on December 7th, 2021. 8 separate parties filed comments. At this point, we will take appearances by those parties, beginning with commission staff.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff. I'd also like to enter the appearance of Lloyd Spivak.
Thank you, Mr. Dean. Maryland Office of People's Counsel.
Hi, Daria Pugh, Assistant People's Counsel on behalf of the Maryland Office of People's Counsel, and also William Fields, Deputy People's Counsel.
Thank you, Ms. Pugh. The Maryland Energy Administration.
Good morning, I'm Nair on behalf of MEA, and I'm joined by Eric Kaufman, Director of Energy Programs, and Samuel Byrne, Energy Program Manager.
Thank you, Mr. Nair. The Business Network for Offshore Wind. The Retail Energy Supply Association.
Good morning, Chairman, Commissioners. Eric Wallace with the law firm Green Herlocker representing the Retail Energy Supply Association.
Thank you, Mr. Wallace. NRG Energy. U.S. Wind.
Thank you, Mr. Chairman and Commissioners. Good morning. Carville Collins with the LA Piper. Also representing U.S. Wind is my colleague Tom Previs with the Saul Ewing Law Firm. Thank you.
Thank you, Mr. Collins, Mr. Previs. Skipjack Offshore Energy.
Good morning, Your Honor. Chris Gunderson on behalf of Skipjack. I also have today Deborah Henry, who's the Project Development Director for Skipjack, and Brady Walker, Mid-Atlantic Market Manager for Skipjack.
Thank you, Mr. Gunderson. Are there any additional interested parties on today's call that wish to make an appearance?
Yes, Mr. Chairman, good morning, and good morning to Commissioners. This is Susan Miller on behalf of Sierra Club.
Thank you, Ms. Miller. I Apologize for my oversight. Good to
Oh,
see
no
you.
problem.
Anybody else? As the parties are aware, the commission issued an order with respect to round two projects last Friday in case 9666. Some of our determinations in that order may impact this rulemaking session today. There was also a request by multiple parties, including both Skipjack and RISA, to have a broader review of some of these regulations. Additionally, some of the proposals that were tendered, I would argue, are outside of the scope of the staff petition filed back on November 15th, 2021. In Friday's order, with respect to the OREC awards for both US Wind and Skipjack, the commission issued a determination that effectively exhausted the capacity for round two. So at this point, the commission does not envision any available capacity offerings for round two, year two, and round two, year three. So there does not appear to be, at least at this moment, a sense of urgency with respect to modifying these regulations. So before we actually look at staff's proposals, as well as the proposals from all the parties, I wish to have a discussion with my colleagues and with staff as to whether the commission should proceed today with these regulations, or would it be a more effective use of time for all the parties to have further discussions with respect to the filings. I recognize that there was no opportunity for parties to have any replies to the proposals that were submitted by the parties on December 7th. Notably, there were some very substantive proposals, particularly coming from the Retail Energy Supply Association. So let me start with that question. I'll open it up to the parties and then hear from my colleagues as to this threshold question of whether we should be deliberating today based on our decision on Friday. Let me begin with commission staff, Mr. Dean or Mr. Spivak.
Well, certainly, Your Honor, you pointed out correctly that we have additional time until any regulations that result from this rulemaking would be needed. Therefore, you're generally absolutely correct in stating that we have time to consider some of the more substantive suggestions and even the non-substantive suggestions.
Thank you, Mr. Dean. I'll open that question up to any of the parties to respond.
Your Honor, this is Skipjack. We agree that it makes sense to postpone and to consider the proposed changes and the comments that the parties have submitted in light of the commission's recent order. I think that makes sense.
Thank you, Mr. Gunderson. Are there any other comments from parties?
Mr. Chairman, Carville Collins for US Wind. Haven't thought a lot about this, but certainly was thinking about it as I was reviewing last week's order. And what you have proposed in the way of a postponement, so long as there is certainty that we'll get back to it, sounds reasonable, sounds like it might also be more efficient. And so for those reasons, I would concur with the sentiments that have been expressed by the staff and by Skipjack.
If I might just add for a moment, if the commission has any guidance it wants to give people at this time, certainly I'm sure everybody would welcome that, but other than that, I have nothing to add on it.
Thank you, Mr. Fields. Oh, Mr. Fields, you're on mute.
Okay, is that better?
Much better.
Excellent. Okay. William Fields for the Office of People's Counsel. We would not object to that, and I think that is a good idea. Some of these issues will still be relevant with respect to how the administrator is going to work, how the money is going to flow if there's a delay in any of these projects. But some of the RISA suggestions, we would like to discuss them more. There are some iterations and tentacles to that discussion that I think would be helped by some further discussion, but it is something we would have to keep working on.
Chairman and Commissioners, this is Eric Wallace from RISA. I appreciate that RISA's comments did include some pretty extensive proposals, or some pretty significant proposals regarding the structure here. And we included those in our comments. We certainly didn't, we believe that the other parties should have an opportunity to review that thoroughly and provide comments. And so we would support a delay until a further date to provide some additional process there.
Thank you, Mr. Wallace. And I recognize a number of your proposals would affect the interests of the utilities, and we don't have a single utility with us today in the room. So perhaps it'll give them an opportunity to digest the substance of your rather substantial proposal. Mr. Nair.
Yes, Mr. Chairman, MEA is also in favor of postponing in wake of some of the statements that have been made today by the other parties, and to give an opportunity to sort of offer a reply to some of the proposals that were offered by some of the other participants.
Okay, thank you for that. I'll turn to my colleagues and ask the question if there is any objection with this proposal to table this. Commissioner O'Donnell?
Mr. Chairman, I have no concern with delaying this. I've long been a fan of the principle of getting things right, not getting things quick or quickly. And we have the luxury of time here. So in my opinion, I think it's the right course of action. I am like you, concerned that the utilities are not engaged with us today in light of potential impacts on their interests. And if I don't know if there's a way for one of our either attorneys in the Office of General Counsel or somebody to contact, maybe through a trade group, maybe the Maryland DC Utilities Association or somebody to clue them in that they may have interest at stake here and may want to engage. I know we typically don't do that, and they have well formulated monitoring capabilities of our proceedings. However, this is important stuff, and we ought to get it right, and they ought to be engaged because it could affect their viability, which we have responsibility for.
Thank you, Commissioner. Commissioner Richard.
Yeah, I would agree that it's probably prudent to go ahead and postpone this. And I think simply my guidance would be for the parties to get together and hopefully give us some comment on all the proposals and hopefully come together, because I think with process, I think MEA, OPC staff have all suggested good ideas. It'd be great if they could maybe come together on those, and that's true for a number of the proposals. I mean, I think what RISA is proposing is very interesting, and I like the simplification aspects of it. But again, we need to make sure that it is well vetted and we get it right. So with that, yeah, I would endorse and support delay.
Commissioner Herman?
Yes, I think it's a much more efficient way to proceed, for sure.
Okay. Thank you. I'll propose a timeline in just a bit for a date when staff is to return with these proposed regs so that this does not continue in perpetuity. However, Mr. Spivak, you asked for some input. Since you have the four commissioners here, with you at this moment. I did
Mr.
have
Chairman.
yes.
Excuse me, Mr. Chairman, I'm sorry to interrupt, but
No.
it looks like I see Commissioner Linton on the line unless I'm mistaken.
Commissioner Linton, I believe, is on the line, but he's not participating with us today.
Okay, okay, all right, fair enough. Thank you.
Thank you. I do have a question for the Maryland Energy Administration. In your comments, you had concerns with the timeline that the commission has, and it is, I would admit, relatively awkward in that we open the window, you have 180 days for other parties to come back, then the commission has 180 days in which to issue the order. However, it appears to be MEA's position that no proposed regulations are needed. That may be possible in case if we administratively put our procedures, let's say, on our website. However, wouldn't we still need to make amendments to our regulations to strike any inconsistent or regulations containing guidance that may send a developer down a different path that is consistent with the current clock? Does that make sense, Mr. Nair?
Yes, that does make sense. I think there would have to be some amendments that would have to be made.
Okay, thank you. I just wanted to make that clear. You may not be advocating new regulatory language, but I think at a minimum, some of the existing regulatory language would need to be removed. Commissioner Herman has some questions.
Yeah, Mr. Fields or, sorry, I'm not sure if it's Mr. Fields or your other attorney, but I was looking at your changes to 06, 01, 05, the except as directed by the commission, court, or otherwise authorized by law, an individual subject to 2302 may not divulge information deemed confidential. Isn't that kind of, I'm really confused as to why that is there. I thought OPC has that in the past argued that they don't even need to sign confidentiality agreements because they're subject to confidentiality by law. So this one is a real head scratcher for me. Maybe you can help me out.
Yes, Commissioner. William Fields for OPC. What we're trying to accomplish there, well, first, the statute is expressly directed to confidential information from the utilities. And what we were trying to accomplish through this regulation was proposed regulation was to streamline the process for receiving the confidential versions of the applications. It's a complicated process when the applicants are negotiating confidentiality agreements among each other and among other parties. And what we're trying to do is streamline it for our office and other state agencies to get that information as soon as possible in the process and not be delayed by dealing with a confidentiality agreement for that has to be negotiated with among a number of parties.
Okay, I appreciate that because that one really had me wondering what the heck you were up to there. Thank you. That helps.
All right.
Appreciate that.
Thank you. Mr. Fields or Ms. Pugh, while we have you here, another question you had with respect to Chapter 6, and I think this stems from our recent evidentiary hearing in case number 9666. You have a proposal where you say that the commission shall establish a date 7 calendar days prior to the start of a proceeding by which an applicant will have the opportunity to file revisions to their proposal. I suspect this is in response to U.S. Wind and Skipjack's last best and final offers that were made during the course of our 4-day evidentiary hearing. Are you suggesting that any potential wind developer would not be able to revise its proposal during the hearing?
Yes, Your Honor. William Fields again. I don't know that they would be. I think we were not trying to absolutely prohibit that. We were more looking for an invitation. I mean, parties can file. You can't stop somebody from filing something. But if we had a date with an express invitation, we'd have a better chance at an orderly hearing where everybody had seen the revisions and been able to formulate questions. The commission advisor could deal with them, could review them as well. Commission consultant is what I meant to say, could do an analysis of them. I don't think we were shooting for a hard and fast rule that it would, a revision would be absolutely ignored, but there would just be a date where those would be expected to be filed.
Thank you. You do raise a good point in support of the orderly administration of a hearing. However, there comes a point in the hearing where questions are asked. The developers, if there's more than one, will hear from their competitors. And as you stated, there's no way to prevent anybody from filing anything up until the eve or the close of the record. So while there's good intentions here, I'm not sure how effective it would be to actually have such a regulation in place, noting that the developers may revise their proposal at the 11th hour. But thank you. That was actually all the questions I had.
Mr. Chairman.
Mr. Commissioner O'Donnell.
Thank you, Mr. Chairman. Let me follow up on that line of questioning to OPC. During the proceedings for both the original offshore wind awards and the most recent order, some of us actually encouraged the developers to reconsider certain positions. And that, in my opinion, benefited the ratepayers significantly, and it benefited the state of Maryland in attaining its various policies more quickly. And yet this seems to be a discouragement. And I'm not sure I want to get into the discouragement business, because I think there's benefit to competitive forces and to the give and take of such a proceeding. And in the first round, both developers significantly reduced their proposed prices and ratepayer impacts, so that we were able to fit what would have been one or the other. We were able to fit both in under the cap. And similarly, I think we saw similar things happen in this most recent round. And why would we want to discourage that? I understand the timely review and the due process issues that you raise, and they're valid. But in these type of proceedings, don't we need some latitude to kind of encourage changes to the various proposals so that they can benefit us and benefit the ratepayers?
Well, I don't. I think we generally agree with that. We wouldn't want to prevent anything, but we do have there is a long period of time between when the proposals are originally submitted and when you get to the hearing. And if you had a date for filing of an updated proposal, and it was at the same time, you could get the benefit of that with an update to the proposal. And if the commission didn't want to, I don't think the commission wants to exclude further discussion of that, but you would narrow, I think, or our thinking is that you could narrow what you were talking about in the hearing as far as updates. You would have less for the parties and the commission's consultant to review as you went through the hearing, trying to deal with things that come up during the hearing. if you did get a updated proposal, again, prior to the hearing that could be evaluated. And then, further discussion, of course, is always going to happen.
Yeah, and I appreciate that, Mr. Fields. And I often have concerns with last minute filings on a broad array of proceedings. So I do appreciate that. This particular subset of proceedings, I think lend themselves more to your general discussion of last minute filings and vetting and due process and adequate review, et cetera, et cetera. However, I think these proceedings here lend themselves to that type of adjustment, even when on short notice. So anyway, just my thoughts. I just wanted to share those. Mr. Spivak, I think maybe you had something to say.
I was just going to raise the issues you just alluded to, Commissioner. That is, there's a balance that's going on here because, as the party that's responsible for helping make sure the commission has a complete record, it's much harder to get a complete record if the basis of the proceeding, that is the proposals that are before the commission, are constantly changing right up until the end of the hearing. It's difficult in that sense, and it's harder for the parties to have an opportunity to completely test and vet the revised proposals through cross-examination, and for that matter, for the commission to do so as well. So that's an interest we want to keep in mind as we consider this issue as well. And you did, as I said, you did allude to it, so it's clear that you're well aware of those needs as well.
I am, and I do appreciate the discussion. Sometimes in these proceedings, I've seen two examples of proceedings where in both of these instances with these two developers, we were able to obtain obvious benefit by that last minute change. And I just want to make sure we're not precluding that as well. But I do appreciate your discussion of proper vetting and proper review. And I appreciate the issue being raised and discussed. So thank you.
Commissioner Herman.
Thank you, Mr. Chairman. Mr. Spivak, you asked for guidance. I don't know if there was anything specific you were looking for guidance on, but for my part, the proposed regulations, a number of parties have proposed an extensive amount of regulation, lots of words. Every time you put a word in a regulation, there's going to be interpretation, and people are going to interpret them differently. And I would just urge the parties to try to be as streamlined as possible. And I'm not exactly sure why some of these regulations require so much specificity. Perhaps it is necessary, but to me, I think I hope that you evaluate that in terms of the great amount of specificity and whether that is required. So that's just a general comment. Mr. Spivak, is there anything else specifically that we haven't commented on that you were looking for guidance on?
No, there wasn't really anything specific. It just, I'm just wanting to get as much of a feel as whatever direction the commission wants to give at this stage. It just kind of helps further discussions proceed along. I do note that staff has obviously reviewed the proposals, and we have our own responses, but we can to those proposals and thoughts about them. But I think this postponement will give us the opportunity to discuss it with all of the parties involved, and I think we'll appreciate that opportunity.
Okay, thank you very much.
Mr. Spivak, I would second Commissioner Herman's statement there. The art of drafting regulatory text is an art. It's not a science. However, to the extent we could use more words than less, and this applies to all parties to this proceeding, I think that's important. I see a lot of paragraphs, not only from staff, but from some other parties, with the exception of Risa, who's taken a pretty heavy red pen to some of the regulations. So please keep in mind, we should be keeping our regs relatively clear, or as clear as we can make them. To the extent we need to break up a paragraph into multiple parts for clarity, that is very important. But I do not have any additional questions with respect to the substance. Any other final thoughts from my colleagues or the parties? Okay, well, what I would propose, since there is a possibility that this upcoming 2022 legislative session may have some legislation with respect to offshore wind, and since it does appear that the parties will need some time to discuss these proposals, which they haven't discussed before with each other, as well as somebody bringing the utilities into this discussion, I'd propose that staff make a new filing with the commission on Monday, May 2nd, 2022, reflective of this discussion and reflective of the actions that the commission has taken in case number 9666. Mr. Spivak, is that clear?
Monday, May 2nd, 2022, a new filing reflecting the results of the discussions. Yes, I think that is clear, Mr. Chairman.
Great. Thank you. Do any other parties or do let me ask my colleagues first, any questions on that? Seeing none. Any other additional commentary by parties? All right. Thank you, everybody. Sorry to change the agenda for this morning on the fly like that, but I believe it will result in a better product, particularly since we have no urgency of time hanging over this endeavor at this point. With that, this rulemaking session is now adjourned. We are off the record. Happy holidays, everybody.